Hello, my name is Jill Carlson, and welcome to This All Stops When We Start Talking About It. Today's episode is going to focus on one of my cases from the 22nd Judicial District of Colorado. Now, before we start this video, I do want to let you know that I will be discussing acts of domestic abuse, and they may be sensitive for some viewers, and so I'm asking you to use your best judgment if you think you'll be triggered by hearing about these things. I will also be detailing crimes committed against individuals by government actors. I don't have some sort of weird axe to grind. This is part of my job as an advocate. Whenever my clients are harmed, I have to do something about it. And unfortunately for these gentlemen that did these things to me, my duty of loyalty to my clients is stronger than any duty I'd ever have to the good old boys club of the 22nd Judicial District of Colorado. I grew up there. I'm a local. Most of the people in the top positions in your county are not. And the reason they came to our county is because nobody else was running for those positions. They knew it was an easy way for them to get their foot in the door. And somehow they've taken over. Now, I don't know about the rest of you, but I don't think they're doing that great of a job. Not all of them, but a lot of them. And we need to be scrutinizing their actions because they're wasting your money targeting innocent individuals, including children. And that's why I had to do something about it. Now, I know there have been a lot of false narratives that have been spread around me around town, and I don't care about most of it. You should know that. That's why I keep living the way I live. But I've heard that I'm a drug addict and I'm mentally ill and I'm homeless and I'm this and that. The truth is this: I'm a lawyer who enjoyed having a side career as a stand-up comedian, and I got some opportunities to tour and I chose to take them, which required me not living in a house for a while. I lived in hotels. It was pretty amazing. I had a great time doing it. That being said, the rest of you have watched me living my life out and proud for over a year, and I don't know if a mentally ill drug addict could fight off the attacks of these government actors because they hit me all at once. I've had a number of cases where there were a number of crimes committed all at the same time, and I do believe there was a conspiracy to take me out. And as this podcast goes on further, I think you'll be able to see that as well. The only reason I can possibly think that they would want to get rid of me is because I was a good attorney who insisted that they followed the law. And I was called a number of names for this, but I'll tell you what, gentlemen, if you want to call me names for asking you to do your job and follow the law, go ahead. You can call me names all day long. I'm still going to insist that you do your job and follow the law. So for those of you watching, I'm asking you to use your own judgment and decide if these are the ramblings of a crazy woman or if possibly there's a need for investigation here. Because I didn't want to destroy my livelihood. I didn't want to sever all ties with my hometown. I didn't want to ruin my career, but unfortunately they did it for me. So now I'm going to tell you what happened because I let them know if they didn't do the right thing. I was going to tell everyone what they did. And I've been waiting patiently for them to do the right thing, and it's becoming abundantly clear they're going to keep committing crimes to cover this up. So I'm putting a stop to it now, and I ask that you join me, if you believe me, in advocating for victims and people of the 22nd Judicial District and letting our elected officials know that we will not stand for this type of behavior in our law enforcement or in our court system, and that individuals who engage in this type of behavior need to be dealt with swiftly and removed. That's my hope. I'm not asking to become a millionaire. I'm not asking for my clients to win. I'm asking for the government actors who committed crimes against multiple individuals in the 22nd Judicial District to be held accountable. No one is above the law, and we need to remind them of that. Today, I'll be discussing one of the cases that I was involved in as an attorney and detailing acts of domestic abuse perpetrated towards my client and the assistance that law enforcement gave to his abuser. That's right, I said his, because men can be victims of domestic abuse too, and I represent a number of them. And I can tell you, our law enforcement and our courts are not addressing their concerns adequately. I know that there's a lot of men out there who are victims of domestic abuse, and they are concerned to come forward because they are worried that they will be treated as if they are somehow weak. And I've also seen how they get treated by law enforcement. I wouldn't have believed it if I hadn't walked near these men while this was happening, but they're treated worse than females, in my opinion. And I don't quite for the life of me understand it. But what I do know is that it hurt a number of men. And I'm going to tell you these stories because I believe that men deserve protection too. First case I'm going to be addressing is a case that I began in March of 2023. I can tell you that I will not be saying the name of my client or his ex-wife's name. I will be saying the names of the government actors involved because I do believe the citizens of the district deserve to know exactly what their government actors are up to and how it could impact them if they ever end up in a court case in the future. I began representing this gentleman March of 2023. He came to me on a referral from another male domestic violence client who knew what this guy was going through, talked to him at work, and said, "Hey, you should get over to this person. She will help you." So I sat down with this gentleman, and in our initial meeting, he relayed to me significant acts of domestic abuse perpetrated to him from his wife, who was, I believe, his second marriage, and they'd been married for 8 years at that time. They did not have any children together. However, she did have her adult children and her almost adult grandchildren living in his home. And so it was him with her and 3 members of her family. Do you believe members of his family ganged up in assisting his ex-wife in abusing him? There were acts of physical violence, one where she threw an unopened can of soda at his head and hit him in the face and cut his face open. She also threatened to kill his pets, which is a form of domestic abuse. She would use coercive control language, threatening him for money. She forged his checks. She stole money from his wallet. She charged things to his name. She tampered with his accounts. And she had done a number of things prior to him filing divorce that would all be considered domestic abuse. Just so you're aware, as you're watching this, if you don't know what domestic abuse is in the state of Colorado, the current iteration of the law, which is changing and it'll be different by the time that this rolls out, but under CRS 13-14-101, the definition of domestic abuse currently at the time of this recording is any act, attempted act, or threatened act of violence, harassment, intimidation, coercion, or stalking. And coercion means essentially forcing someone to engage in something they have a lawful right to abstain from, or forcing them to abstain in something they have a lawful right to engage in. That's the basic definition. So again, any act, attempted act, or threatened act of violence. So if you say, "I'm going to shoot you," that could be a form of domestic abuse that would be subject for a protection order. So I sat down with this fellow and I started looking at the threats his wife had made to him through text messages, the threats his adult daughter-in-law, I guess, had made to him. And essentially, I told him, listen, this is not going to get better when women or men are at this point making these types of threats. When abusers are at this point, they are going to take action. It is smarter for you to protect yourself. I don't want you coming back to me a week later when you have criminal charges because she's tried to set you up, saying, "I wish I would have listened to you." Because one of the most common threats that I have seen abusers make towards their victims is accusing them of doing exactly what they are doing to their victims, making themselves the victim and their victim the perpetrator. And I believe that's precisely what this woman was going to do. So I tried to talk him into a protection order that day. He was a little nervous because he doesn't want to be seen as if he's weak. He has lived in the area for the majority of his life. He's well known he was well known in his small social circles, and he didn't want people to think that he was a victim, which is really common. Nobody wants to be seen as a victim. So he left the initial meeting, and he wasn't going to get a protection order, but that night she called him again when he was out of town for work and threatened to kill his dog. So he drove 8 hours from Denver back to get his dog in the middle of the night out of his home and called me the next morning and said, "Okay, I need to divorce her and I would like a protection order." And that started the most arduous year and a half of this man's life. There were a number of government actors who undermined his protection order and went out of their way to help his ex-wife harass him. So we filed the protection order. She violated it immediately. The protection order included the act where she hit him in the head with the soda can. It also included her threatening his dog, her making a variety of other threats to him. And she violated almost immediately upon being served. Now, what's interesting about the service is, I don't know if you're aware of this, but if there's a domestic violence-based protection order that's entered, you are required, or the sheriff of your county is required to serve domestic violence-based protection orders for free. Now, I know this to be a law, and I also know that I've had difficulties with that with Dolores County, with Don Wilson in the past, where I've had to actually go to the courts and say, hey, he's not serving protection orders. So I know that Don now knows the law. I didn't want to have to do that to him, but I've had issues with Don Wilson not properly addressing domestic violence victims for years. In fact, in November of 2016, when William First was still the district attorney, I wrote an email to Will long before I represented this gentleman, letting him know that Don Wilson was not taking records of domestic violence responses. And he was also directing victims to not call 911 and instead to call his cell phone. I believe this was done deliberately so that there would not be an official record of their calls. And I also know that no reports were taken on a number of domestic violence and SA events that occurred in Dolores County. I let Will First know about that in November of 2016. So he and everyone else in the DA's office is well aware that there is a history of this type of behavior happening in Dolores County. And in this case, it happened again. So we went ahead and we filed for the divorce and the protection order. It was granted. She violated pretty much immediately. I told my client, listen, it's up to you. You can call it in or not. It technically is a violation, but it's a minor violation. She texted him. Basically, he was kind of, I said, maybe just let things simmer. Because, we start a lot of cases with domestic violence-based protection orders. Unfortunately, domestic abuse is a huge problem in the 22nd Judicial District. I'm sure most of you have been impacted it by some way or another. That being said, I also know that sometimes there's a cooling down period that we can implement in a case. And usually if people come to their senses and move on and realize they're going to get divorced, they can move on with their lives and coexist in the same community. Unfortunately, that wasn't the case here. We went ahead and we got that protection order, and she was doing some minor things. She was granted one civil standby under the court order. Sheriff Wilson and I believe Lieutenant Braden Banks allowed her to have 4 civil standbys, where they basically cleaned out almost the entirety of my client's house, all of his furniture, everything that he owned. They even engaged the Dove Creek High School baseball team to come help move everything out. My client sat there in a chair watching as all of his belongings were moved with the assistance of the sheriff. I don't know why the sheriff's office gave her multiple times to go in there. And I don't know why they assisted her. If any of you have ever had a civil standby, you'll know that officers really don't like doing them. And they usually are a maximum of 15 minutes at a time, not for hours, and not with the assistance of 18 high schoolers. Furthermore, I don't know why they would involve children in something like that, but besides the point. So that was right at the tail end of March, beginning of April. And then on April 7th or 8th, I can't remember which day, right before Easter Sunday, the Saturday before Easter, I received a phone call from my client. He notified me that he'd been having a family dinner. His whole entire family, all of his children, adult children, had come to his town to spend Easter with him. And in the middle of that meeting, his ex-wife contacted him and started screaming at him, calling him names, calling him every name under the sun. And at that point, he realized, okay, I can't do this anymore. I got this protection order. Sheriff's office is not enforcing it. He called the sheriff's office and told them, hey, she just contacted me. Now, just so you know, his protection order said that there was no contact allowed and she was not allowed to be within 100 yards of him. No contact, no exceptions. That means no texting, no emailing, no Facebooking, no tagging, nothing. No contact. Whenever my client contacted the Dolores County Sheriff's Office, they told her that they were allowed to have contact. And that required me on my holiday weekend to call the sheriff's office and speak to Phyllis Davis, your recently elected county commissioner, that, hey, this is a protection order. And she started to argue with me on the phone. And I said, well, it's interesting, Phyllis, because actually you, for some reason, when I had you serve the paperwork to my client, you made me give you a copy of it. But don't worry, I'll send you an email right now. My client's waiting for you to go take your report. So that day, Lieutenant Braden Banks, knowing that they were caught, knowing that they were required to enforce that order, and knowing that under 18-6-803.5, when they have probable cause of a violation of protection order, it's a mandatory arrest. He went and arrested the ex-wife. In the meantime, the ex-wife's adult daughter tried to run my client's daughter off the road with her grandson, with her child in the car, my client's grandson. At the same time, my client's daughter got a ticket from the Dolores County Sheriff's Office for a dog on the loose. She believes the adult daughter let her dog out and that it was a setup with Coty Kelshaw, who was waiting outside of the daughter's house to give her a ticket. Now, the daughter was also charged for, I believe, menacing or something like that. Bizarrely, her case was transferred to the 7th Judicial District under claim of conflict. The Dolores County Sheriff's Office never delivered the evidence to the 7th Judicial District, so that case was dismissed. And my client's daughter never got justice for almost being attacked in a vehicle with her child in there. Also, my client's daughter was pregnant at the time. Dolores County Sheriff's Office was incredibly oppositional to both of them, both my client and his daughter. And at that point in time, I said, "This is ridiculous. Let's get you both protection orders." So I got a protection order for his daughter as well. We had a hearing on April 10th. Now, the wife was sitting in custody. This is something that you should know. If you get picked up on a domestic violence charge and it's over a weekend, because of the nature of domestic violence crimes, you are required to sit in jail before you can be seen, or you have to be seen by a judge before you can be bonded out. That is a requirement. So on April 10th, which I believe was the Monday, we had a hearing, an emergency hearing, on the protection orders for both my client and his daughter. Meanwhile, the wife tried to file one against my client, claiming that he was SAing the adult or the teenage granddaughter because he went through her underwear drawer. None of it was true. She was just trying to make herself the victim, which was interesting because whenever I first talked to the sheriff about this case, he was ready to go arrest my client because he assumed I was representing the wife, because about 2 weeks before we filed, the wife had been in there telling everyone that she was a victim. Now, I don't want to broadly generalize, but generally victims don't go out and tell everyone they're a victim. Usually victims are afraid and terrified of what's going to happen to them if they ask for help, like my client was. This woman was telling anyone who would listen that she was a victim and that my client was doing these horrible things to her. And my client wasn't even there. My client was in Denver. So the judge denied her protection order. She was released from jail. She was admonished and told she was given a criminal protection order because of the initial case. Now, bizarrely, Drew Buffington was the district attorney in that case in Dolores County. And for some reason, he filed the case as a non-domestic violence case, which the reason I'm bringing it up is the statute requires the DA to charge it as a domestic violence case with the sentencing enhancer so that my client gets the benefit of the Victims' Rights Act protection, because you only get Victims' Rights Act under a violation of protection order if it's a domestic violence or domestic abuse type of charge, which this was. Furthermore, in order to not file it as a DV case, the DA is required to make a special presentation to the judge demonstrating that they were unable to determine whether or not my client had been intimate partners with his ex-wife, and everyone in town knew they were going through a divorce, including Drew Buffington. So I don't know if that was a mistake or if that was done deliberately, but what I do know was that my client was kept out of any decisions pertaining to the first case. Um, in addition, after she was released from jail, I believe she was released on the 10th. On April 14th, a couple days later, after she was admonished and told she was not allowed to contact him, she was not allowed to interfere with anybody he associated with, she was not allowed to interfere with his employment, she called and left 2 messages with his employer. Now, this was at the same time his adult daughter was telling everybody that she was going to have his job. She was going to tell everybody he'd been drinking and driving in the work truck, that he had stolen things. And she was sending unhinged messages on Facebook and text message to anybody associated with him, pages and pages and pages of rants. And they did call and try to get him fired from his job. Fortunately, I anticipated that she was going to try this. And so it's not something I do frequently, but whenever I have a client in this situation, I say to them sometimes, "Hey, I know it's not normal for me to talk to your employer, but if you would like me to write them a letter to explain what's going on, I will do so, because you can't get terminated because you're trying to leave an abusive relationship. And if they terminate you because of that, that would be grounds for you to sue them for retaliation and wrongful termination." But I said, sometimes just letting them know what's happening especially since she's not prohibited to go to your workplace because of the protection order is an easy thing to do. And his workplace was amazing. They were Johnny on the spot. They were absolutely delighted to get in there and help him. And so the woman who had received the voicemails sent them to me. I forwarded them to Matt Percat of the sheriff's office, who told me he wasn't going to charge anything, told me they weren't going to go forward on it, which is interesting because right in 186-803.5, I believe, it says if a person's awaiting sentencing or awaiting a hearing on a violation of protection order, which she already had one, they are required to notify the judge of this. They are required to basically charge her a second time because they had probable cause, because they had recordings. And basically, her sentencing should increase, her penalties could increase, including potential that she could get new violation of bond conditions charged. But they didn't want to do that, even though I gave them evidence. Now, what we found out later is that actually Matt Percat did file an application for a warrant, which was granted. And even though the woman lives in Dove Creek, they couldn't find her to serve her, even though she was wreaking havoc all over town, messing with my client. My client made numerous calls to Dolores County Sheriff's Office trying to get assistance, and so did his adult daughter. And so fast forward to, I believe, May 14th of 2023. The wife was supposed to have her first ever hearing, her first arraignment on the first criminal charge that was from Easter. On that day, we don't really know what happened because my client wasn't invited to the hearing because he wasn't a victim for the purposes of the Victims' Rights Act because of the incorrect filing of his case. And on that day, they introduced the new warrant, allegedly served it to her, and then dismissed that case and gave her a 6-month diversion with absolutely no terms. Now, this is a violation of the law as well, because under the sentencing guidelines and the Colorado rules, it states that you're required to make a person accused of domestic abuse undergo a domestic violence evaluation before you sentence them. And she had one hearing where they took care of 2 cases and gave her absolutely nothing. 6 months, no terms, no drug testing, no domestic violence evaluation. In fact, when we tried to get a copy of the document in November of 2023, it wasn't in the court case. And the one the DA's office finally sent me had a different charge on it and wasn't signed. So I don't know exactly what happened in that courtroom, but it reeks of good old boy corruption to me. What I do know is that things did not get better for my client. And as soon as she was emboldened to continue abusing him, she did so. The entire summer, she and her daughter and anyone associated with her would harass him. They stole property from him. In fact, there was a flatbed trailer that we could not find that she had taken. We located it at the residence of one of the Dolores County residents, and I contacted Sheriff Don Wilson to ask for his assistance in retrieving the trailer so that we could hold it until the divorce hearing was settled and make sure we preserve the property. And instead, Sheriff Wilson notified that woman's grandson to pick up the trailer before we could get there. We went through the divorce. The divorce hearing actually went rather well. William First was the judge. He was still relatively new to the bench, and I think it might have been one of the first bigger divorce hearings he had done. And I was pretty happy with how Judge First did the divorce hearing because since he didn't really know a whole lot, he let me and the other attorney sort of make proposed orders and recommend things to him, and he listened to us. And I know the ex-wife wasn't satisfied with what she received because she wanted more than she was entitled to, but my client was happy and he felt like everything was great. But almost immediately upon the divorce being granted, the campaign of terror started against him. The day the divorce was granted, she tried to file another protection order against him in Dolores County, which was immediately rejected. So she just lied and she went over to Montezuma County, San Juan County, Monticello, and filed a protection order there. So my client, coming off the high of my divorce is over, is being now harassed by San Juan County Sheriff's Office, threatening him because he wasn't doing anything. This woman was just trying to get him in trouble. There were multiple complaints called into the agencies that oversee his employer, claiming that he was stealing things and committing crimes on the job, which required agents from the state, investigators, to come down and interrupt his entire workplace. From what I know, she located his boss in a motel room in, I believe, Moab, Utah, and assaulted him in the lobby, started screaming at him, threatening him. Um, she harassed his bank tellers. She canceled his trash service, his homeowner's insurance. We reported all of these things to the Dolores County Sheriff's Office. There's not a single record of him. And when I asked Don Wilson why he didn't have records of these things, he told me it's because we only document if we choose to dispatch a deputy. So real easy. Just choose not to dispatch anybody, and then there's no record of the call. And because I was making my clients call their number instead of Don Wilson's cell phone, I know for a fact there's a record of those calls. Or there should be, according to the law, because Don Wilson's required to keep them. So I'm trying to wind this whole thing down, and in the meantime, she's continuing to escalate. Now, you all know football is pretty popular in Dolores County, and everybody likes to go to those football games. Well, she started harassing him at football games. Now, again, there's protection order in place. In fact, we actually had to have Judge First make the language stronger in it because she was continuing to do more and more stuff. And so the cops are all aware, the sheriff's deputies are all aware of what's going on. In fact, a number of them came and watched our court hearings. Isn't that strange that a bunch of sheriff's deputies would take time off their day to come watch a divorce matter? But interesting. So at these football games, my client and his daughter, who again at this is very pregnant at this point, are literally being harassed by these women. They attempted to call for assistance. I know that Coty Kelshaw was one of the responding officers. He called my client's daughter back and told her he was sick of this shit. And if she didn't stop calling, he was going to arrest her for charges. Excuse my language, but that's what he said to her. And on top of that, my client was continuing to call and continuing to ask for assistance. He said that he was at a game and Braden Banks looked at him and smirked, winked at him, said something to him. One time he was in the courthouse and Matt Percat came up to my client, elbowed him and laughed and said, "She's continuing to file false complaints against you." The sheriff's office thought this was a joke. Meanwhile, my client, whose divorce case was over, was having to spend more and more money with me, a private attorney, trying to get assistance because he couldn't get it from the district attorney's office because his cases were filed as non-victim cases. So there's more. I want to keep these short and sweet, but I want you to react to that first one because it gets worse from here. And I don't want to make these videos so long that you won't listen to them. I need you to hear what happened here. I need you to hear the crimes that were committed against these people. And that right now you might be sitting there scratching your head saying, okay, well, what's the big deal? I don't quite understand everything. Big deal is this. Your government actors are committing crimes that are subjecting them to liability. And that means that your county could get sued. That means your taxes could go up. Now, it seems like the easy part of this equation is getting the bad actor out. But for some reason, we want to keep them in there. And I think it's because everyone's afraid. I know some of you are afraid. But I'm going to go back to the name of this project. I believe 100% this all stops when we start talking about it. And furthermore, I'm doing this to get out of my county because my county's intent on making sure none of this comes to light. And I would imagine that my case is just the tip of the iceberg. I would imagine there's a lot more going on there. And I believe it needs to be investigated. And for the life of me, I can't understand why government officials would be more content to just call me crazy than to actually look and check and make sure that their machine is running correctly. I might be crazy, but that doesn't mean I'm not telling the truth. And it definitely doesn't mean I don't have the evidence because everything I just told you, I have a piece of physical evidence or a court record to back up. I can prove everything I'm saying. They can't prove anything they're saying about me. I hope you enjoyed this program and stay tuned for the next one because we're going to get on to part 2. We're going to talk about those football games and what happened in November of 2023. Thank you.